Okay, so this second part actually speaks more about the laws regulating the professions in the real estate, namely the notary and also the real estate agent and other people that might be involved. So, first of all, we're speaking of estate agents, brand managers, property consultants, and property brokers, and notaries, as I said, and both are considered as subject persons in terms of the anti-money laundering framework. You have a whole module on anti-money laundering framework, and so this will be dealt because it's a whole module dealt in depth and the repercussions in this relation. So let's start with the notaries. The notaries are regulated by the Notarial Archives Act, Chapter 55, which is one of the first chapters. Notaries have been existing in Malta very long time. And if you go into the historical archives in the National Library, this goes back to 500 years ago, when practically we have the history of how the land also was owned by feudal owners and how the nobles, and so there is a lot of history related to the notary profession. So Article 2, subclause 1, speaks of notaries as public officers. So it speaks about public officers. Why? Because, and this is distinct, even if they do the same degree, a notary usually stops it's in the fourth year of the studies in law, and though he can continue to study to become a lawyer, but then at the end they choose whether they want to practice either as a notary or a lawyer. So notaries cannot practice as lawyers, and lawyers cannot practice as notaries. And they are considered as public officers because they are there to regulate and document contracts, agreements between people that become of public nature. So they can also document things of private nature. In fact, we speak of private notes but they are public officers because they should be independent. So they are charged to receive acts inter vivos and wills. So inter vivos, it means between two living beings. Okay, so two persons. And wills, so wills are inheritance, and to attribute public faith thereto. So they are there to represent them publicly, so independently. They shall be responsible for their custody and shall give out copies and extracts of or from such acts or wills. Wills are inheritance. Acts is like the contract of sale. Okay, so why they are called public officers? Because they should be independent. So the tradition in Malta is, and this is to safeguard the independence of the contract of sale, is that the buyer chooses the notary. However, there have been quite a number of instances, I think more recently, that developers offer their notary. However, this might have repercussions. And I can give you an example. I had one condominium, I will give it later. Why? Because they might favor the seller. And as I said previously, if you have an issue of law, of interpretation of law, during a contract of sale, the notary might explain, but might not, but will not, never, according to the ethical conduct, give an advice either to the seller or to the buyer. Do not buy or buy. Why? Because they are not advisors. They ask the seller or the buyer to go to a lawyer, and even you, as an agent, I think you should take also that position. Why? To safeguard your profession. Because at the end of the day, you don't want your client being either the buyer or the seller, because both are your clients, and this needs to be clear in a real estate agent's mind, that because you are going to take money from both at the end of the day. So you are not advisors to buy or not to buy because of legal issues. You might explain the repercussions or the intricacies, but then it's up to them, up to the seller or buyer, to go and seek somebody in whom they trust. And I'm saying lawyer and not another notary. Why? Because notaries will never give advice, but a lawyer is there to give advice and to defend the client. Okay, this is a big difference between a notary and and the lawyer, and that's why even if a lawyer does not agree with a murder, he will be there to defend the murderer as not guilty. Okay, even if personally he might know or he might have a hunch that he has murdered, or I'm giving him an example of a murder because it is extreme. So they are public officers because at the end of the day, even if they do not work for government, they are there to publicly um, um, uh, to publicly witness and control a contract, an agreement. They have to have public faith. So they have to have the trust of both parties, not of one party, but of both. Okay? A document issued by the notary is considered to have the seal of the state. Okay? That's why also they carry the public office. Why? Because that contract, then if it's taken to court and whatever, it has to have been trustworthy. Okay? And that's why they carry a lot of responsibility, notaries. Why? Because they are also trusted with money during contract of sales, and that's why there are a lot of repercussions if they. We had cases in Malta of fraudulent activity from notaries, and they will have to carry a lot of weight because they know the law. They know that they have to be independent. They know that money is not theirs. Okay, and that's why they seek consent of the buyer whether they pass the deposit to the seller or not. Okay, so it's an official document what they're doing, and it's going to be published. Okay, so responsible for custody and giving out copies as a part of this public faith. So agreements are not private, agreements are public. And at the end of the day, you can find an ID card, my ID card, and go and get my actually my what I've bought, they are public and whatever. So the law has a very clear position and very clear parameters around the profession of a notary. Other notarial powers are signing acts before court of voluntary jurisdiction, so they can sign oaths, okay, authentication of signatures. For instance, if you want an apostle, you might have also encountered this, maybe situations where you have international buyers and they need to have verification of documents from another country, and they need to be apostilled. But before apostling, you go to a notary so that the identification and the signings actually are verified by the note. Give out certificates regarding proof of life or existence of persons. Draw up protests for non-acceptance or non-payment of bills of exchange. You will not get into these. Certify copies, that might also come into your situation. Act as mediators, okay, so, but they need to keep themselves independent. And mediators, this happens more in situations where you have like marital separations, etc. Okay, so that is quite common in the situations. And act as commissioners for oaths. Okay, so you go and take an oath. Drafting of private writings that create legal rights and obligations. So a private note, you can have a contract of sale, and then between the seller and buyer, they sign a private agreement. So it will be a note, okay? And that is not published. They agree that this part will not be published. Okay, so that can happen, and it's quite common, I think, in certain situations. Examine title to movable property, and this is something that you will be encountering as real estate agents when they do searches. We call them searches in the public registry. So you have to give them your ID cards. Of course, they will have them through the promise of sale, and practically they would do searches on both sides, so on the seller and the buyer. It's sort of due diligence, okay, that the property is of the owner, that the property is that the buyer has no infringement to buy by court, so that they are free to buy and sell. Okay, so this is very important. The word free is they are free to buy and sell. Okay. So the notary duties may not be bound to give his services whenever he is required to so, but cannot refuse services in case of will or see protest. So there are two situations where if I want to go and do my will, they cannot refuse. They have to do it, and they do it according to why I do it, and see protest. Okay, this is something which is very particular. It is illegal for notary to receive acts that are, first of all, expressly prohibited by law or manifestly contrary to good morals or public policy. So, actually, this is why they do searches, because if a person does not have a title of a land or of that building, he cannot sell. Okay? And it is against the code of conduct of a notary, and it's illegal that they do continue with the contract. Okay? Documents where parties are spouse or related by consanguinity in the direct line or in collateral line up to the third degree inclusively. So that is, they cannot actually do contracts of sale to persons who are related to third cousins. Okay, so this is mean third degree of inclusivity. Sorry, second cousins. So sisters or brothers, cousins, first cousins, and second cousins. Wills having provisions in his or her favor or between inter vivos, between living beings, having provisions in their favor unless this is allowed by law. Okay, so if the law permits that wills are done between people, for people, so they are according to the law. If any party is prohibited by law from entering contracts or disposing of property. This is what I have just said, that it is illegal for a notary to continue with a contract of sale when an owner does not have full title of that property. In fact, when I bought my house, the wife of the developer was not present, but the notary asked him for the proxy, general proxy, which will be also signed in front of a notary, okay? That he is allowed to sign contracts on her behalf in her absence, okay? So and this happens a lot with contractors or with company directors. Why? Because it's very difficult at times if, let's say, you have a company with 4 directors and one is abroad to find a date and whatever. So when it comes to relate to your situation, this last point is very important because the notary has to check and validate that the buyers and the especially the sellers now in this case have title of that property. Keepers of notarial acts. So the notaries are deemed of the custodians of the documents which they published. So and this is a big problem at times when you go to look for old contracts. Some notaries are very organized. Today with technology, this has hugely improved because they scan. Usually a notary has a photocopier with a scanner. They scan documents immediately, they file them. Why? Because you have but in the old days, notaries might have been very disorganized. You will not find a contract, etc. And when a notary ceases to exercise these functions, they should be entrusted to another notary. So, why? Because they have this obligation at law. Okay? Keeper not responsible for the payment of dues. So registry fees, tax, can claim any expenses made. So this happens a lot in contracts of sale where there are, of course, the notary collects the taxes, but then also collects all the expenses that are related to registry, etc. And they will provide you with the receipts. For instance, when I bought one place, these were very thick actually a lot of searches. And practically it cost me, I think, at that point in time, it cost me around 700 or 800 euros. So in your case, if you're um, selling apartments, you can help the buyers to save money, especially if you know that the searches are you are not allowed to keep a copy of the searches, okay? But you might know another buyer. You're going to sell a second apartment or a third apartment of the same block, and today we have a lot of big complexes or big blocks, and practically you are another buyer, and to save some money, you ask the first buyer, maybe he will be ready to photocopy those searches, um, um, and uh, and uh, and give a copy, of course, paying him. Okay, so without maybe divulging the other buyer. So that can help at times, especially young people. It's nothing illegal, and you need to have agreement with the notary on this, the promise of sale. So, and with of course with all the parties. The notary has the right to claim any other extra expenses that are due because they deposit the money, they pay the tax and searches and whatever. The notary deposit accounts, so notaries to open accounts with a local commercial bank. So usually what today they do, notaries, they would have a specific bank account to deposit all the monies um, according to his professional capacity. So usually deposits are withheld at the notary, that are given by the the buyers to at the promise of sale, and notary should have always at least one such open account, so they do not deposit them with their monies. This used to happen a lot in the past, and there will be we have a couple of notaries that had a huge number of problems to keep register of monies, so they deposited and also spent, not to divulge except on court order, so they are bound by professional secrecy, holds on account of person deposited for, and interest accrues to notary only against his services for operating such accounts. So he is not, today bank accounts do not have a lot of interest. Okay, so um, and the interest that he takes is just as a sort of remuneration for operating such accounts. Personal creditors cannot attach this account, and the money does not form part of personal estate nor of the community of property. So those who are creditors, or people who, so if you are going to pay a notary by bank transfer, so he should give you another bank account. Okay, so you pay him for his services, he should give you another bank account, not the same one for the deposits of so when it comes to contract of sale, the appearers, so the buyer and sellers, should appear, or the representative agents. There should be presence of two witnesses, only required if parties request. So if parties request witnesses, they ask for witnesses. They can be witness of themselves, especially when you have couples where any appear does not know how or cannot sign name. So there should be, if somebody does not know how to write or read, they should bring somebody who knows how to write and read. Public wills, okay, and so in contracts of sales, you do not need witnesses. those who are the buyers and sellers are witnesses of themselves. But in public wills, they need a witness, and delivery of secret wills. So there should be a witness also when will is delivered. Notary to direct drawing up of the act. So the notary has the responsibility to draw the contract. Notary alone is competent to ascertain parties' will or to inquire after reading and explaining the act. So the notary, it has to be physically present, okay? Cannot, he has to be physically present during the contract of sale, during the opening of a will, during the reading of a will. But there can be exemptions from reading and explaining the act in limited cases. Maybe he will be present, but it's an old notary and he has difficulty with visual or whatever, and so he has a reader. So those are situations where maybe there is an exemption. So forms of acts. So a notarial act should contain always. So a contract of sale should contain this. And this is where these are the first three paragraphs of a contract. In full, that is not the number. So if I say today is the 5th of September, it has to be written 5th, written F-I-F-T-H, of September, okay? In full and in writing, day, month, year. For wills, even the time. So why? Because somebody can die, okay, during the will. So that's why they write the time. Name and notary, surname of notary, personal details of buyers and sellers, identity document number of those who appear as well as witnesses. Okay, so if you have witnesses, they need to have also their dates, sums of money written in full. So if you're going to sell a place of 2 million, it has to be written 2 million, MILLION. So, and written in full at least the first time. Words prevail over figures. So there might be mistakes in figures, but what is written in words does prevail. It is binding by law. Okay? So if there is a mistake in the words, it's not the numbers that count, but the words. So this is very important because notaries are humans like just other people. Precise description of things. For description of immovable property, order of description, city, street, number, or tree of its boundaries. So if it's not built, or they do not have number, they need to write something like this. So let's say, my house, actually, where I live, it did not have a number when I bought it. It is called plot 27 and 28. The number was given to us, the proper numbering was given to us about 6 months ago. And so the notary was she. The notary has written, and on my side, there is a field, so it's not built up. And at the back, there is a lane, a small lane. So she has written plot, because she was not sure. So plot 2728, the name of the street, the name of the town, adjacent to, on the northwestern side. So she takes the compass. Okay, if you don't have buildings on the side, and on the other side there is no building, so also because there is a passage. So she took the side on the northern western side, there is a field, and she I don't remember what that is exactly. She called it, and then the back side with the direction of the southern eastern side, there is lane called I think it's Main Street, lane number 3, just. And so, and she has to annex a site plan. So this site plan has to be part of the contract. Okay, so this is very important because you are the agent to know that I can show you a site plan at the end. So because or upload one. So because at the end of the day, the site plan is indicating exactly the location of the place. Mention any titles and papers annexed, so they have to speak of the adjacent annexes. Statement if duly having explained contents before publication, so they should read, as I said, the contract. Okay. Statement that published in the presence of witnesses were required. Detailed indication, so they will say where it's being published. Usually in Malta, we have 2 public registries, one in Malta and one in Gozo. So if you're going to do a contract of sale, it will be published in the contract of sale in the public registry in Gozo, sorry, in Malta. If it's in Gozo, it's the public registry in Gozo. Signatures and certain formalities, drawn up in Maltese or in English. So this might be for those who are non-Maltese speaking. If the notary is reading in Maltese and writes the contract in Maltese, because it can be beneficial for those who are doing the contract of sale. The Maltese is also the official language of the contracts. Delivery of note to the public registry. So the notary has to deliver within 15 days to the director of the public registrar a note of certain deeds, and also giving a copy, okay, listed in Article 50 of their, including. So in your case, inter vivos, it means a contract between 2 human living beings, acts referring to movable property or other real rights. Real is real estate, yeah. Creating or transferring servitudes, usufruct, which is usage as a result of a contract, use or habitation, removable property, or renouncing such. Ephromatosis or sub-ephromatosis, this is ground rent, okay, reduction or redemption of ground rent, or renunciation of rescission thereon. Okay, so renouncing, for instance, there could be a ground rent on a property and it has been renounced on the sale of the property itself. Okay, so it was closed on the, so you have the sale of the property, and in the previous contract there was the ground rent, and the ground rent was rescissioned. So practically it's closed. That's what it means, rescission. Any act of compromise affecting immovable property. Okay, so there could be a second agreement on an immovable property on certain things. Any act of partition of immovable properties, or any declaration affecting the ownership of immovable properties. For instance, there is still debt. Okay. and who will be, so there will be another contract on the debt. Okay, so law specifies the contents of the note. So the law, the notary, this is, you don't need to know, but how the notes should be. Notary to register legal hypothecs or acts relating to it. So most probably this, you have also encountered this, that during a promise of sale or a sale, people buy a property on a loan, and the bank has a general hypothec on that property. A general hypothec, there could be a particular hypothec or a general hypothec. A general hypothec, it means that the bank, in case that it does, that in the case that the buyer does not um, um, pay the loan, the bank has full rights to take that property. Okay, that is general hypothec. Particular hypothec, it could be not on the full property, but it could be specifying what type of hypothec. It could be money guarantee. Okay, so and that is also done with the bank. Examination of title, I also mentioned this during the first part, where the notary is empowered to compile documents conducive to establishing the title of the movable property, because this is very important, because there is where a contract of sale can fall from the part of the seller. And it is automatic. Okay, so this is automatic, and causes of preferences among creditors affecting their title. So there might be creditors that are still entitled on that property. Okay, has the right to interpret the compiled documents and give advice thereon. So in this case, the notary has to decide whether the seller has title in full or not, and what can be done in order to safeguard maybe the sale of property and not fall. And it could be that the creditors come in and sign a parallel a parallel a parallel um, a parallel contract, or let me give you a very clear case. So so let's say the so the developer has a loan with the bank, okay, and I will mention to banks, it's not public, it's not advertising this. So the developer has the loan with BOV, and the contract and the buyer is going to take a loan from HSBC. The and this is a little bit funny. The developer might have taken the loan subject that when the developer is doing sales, the bank has to take a certain amount of to redeem that part of the loan. For instance, the developer on the loan has a condition that if he sells a property of 200,000, the bank is due to recover 150,000 of the loan of that the developer has. So a bank representative from BOV will be present during the contract at HSBC, okay, and practically, so this is part of the role of the notary, and actually they will tell the seller, listen, during the contract there should be a representative of BOV, and this is when it becomes the headache to do appointments with the two banks and whatever, and during the sale itself, 150,000 will be issued directly to BOV. They will not pass through the developer. Okay, why? Because that is a condition as BOV as a creditor to recover the monies. Okay, so it's the responsibility of the notary to view all these things. If there are loans, if there are so so these are part of the role of the notary, which are very important because that is about validity of the contract of the sale. Responsibilities of the nature might be delegated. Yes, of course, she might ask or he might ask somebody to do it for him or else to another notary. Notary may examine title whenever he is instructed to do so by a written contract of engagement. Okay, so notary who publishes a notarial act of transfer of ownership of immovable property or real rights over such property shall be deemed to have been instructed by the transferee to examine its title. Okay, so this is these are automatic. The law establishes these rules, but when you go to a contract, the notary automatically knows that they have to do searches. Okay, so it's an automatic authorization once the promise of sale is so in fact it says notary may be exempted by transferee to state so in the deed. And this reminds me of something that I wanted to tell you previously about a case where I had in I had in a common parts. I will not mention it because it's quite known the place. And in this common part, the developer assigned me to be the first administrator of the block. He trusted me. He told me, listen, speak to my notary, and he had a plan. I didn't know, but he had a plan. And he told me, speak to the notary and discuss with him the rules of the condominium. And he told me, listen, as a developer, I don't want to pay the common parts fees. I told him, you need to put it in the contract. Why? Because if it's not in the contract, so you're liable. And this guy, actually, I didn't know. At first, I didn't really notice. I noticed the rules of the condominium, and that's all. But this guy really put it in the contract. And when I took the administration, I had a big issue with this because many people thought that the developer has to pay. And then I asked them about the contract. The developer at that point in time still had around 10 apartments which were not sold out of 30. And this is about division of fees at the end of the day. And he knew that he was not going to sell immediately. And the issue was that at one point I told them, listen, I need to see your contracts, whether the developer is liable to pay or not. And the contract started to come. And most contracts, except one, had the wavering that the developer is exempt from paying the common parts contributions. So I told them, listen, you have signed this contract where you waiver that contribution. There was one of an Italian, and I know what happened with this. one of an Italian. I think he chose his notary. The others trusted the developer and they used the developer's notary. And I know why, so that they will will uh, will save the searches. Maybe had a lot of searches to do. Um, uh, of course, they saved amounts amounts of money of searches if he exempted from if he managed to share them, and practically he waived he was waived from the common parts contributions, and this guy was the only one. Most probably, he took them to another notary, and his notary told him, "Mm, you can take off this clause, okay?" Or he did not do it in the clause because usually notaries do not do this. And actually, the developer was waived from, so the notary may be exempted by the transferee not to examine so much things and it has to be stated because it's an obligation to exercise diligence in this function. Okay, so let us speak about your profession according to the law, and there are three types: the real estate agents, the property brokers, and the property consultants. So, according to the law, the property broker means any natural person, so it's not AI, okay, who has a license, okay, that's why you're doing this course, to act as intermediary in the process of negotiating and arranging transactions involving the acquiring or disposing or leasing of land in terms of this act, and does not employ or engage, whether under a contract of service or contract of services, that is employed or um, um, or self-employed, any branch managers or any property consultants. So this is about the sole trader. So this is about what we call Sansar, okay? And so there is no agency, no, and the person is acting on his behalf. So he's the sole trader working in his own name and under their own responsibility with no employees. Okay, that is means so they do not work with an agency. As we said in the first lecture, they have 1% the seller and 1% the buyer. The definition of a property consultant means any natural person who has a license to act as an intermediary of negotiating and arranging transactions involving the acquiring and disposing of land, which is the same, as and is employed or engaged, so contract of service, okay, by an estate agent, like most of you are. Okay, so you work with an estate agent. The agency is not yours, and you are there under a contract of service or employed. So you will receive a basic salary every month. Works under the directions of the same or those of a branch manager. So you have a branch manager on top of you, okay, or a senior property consultant. So individual is an employee and reports to the estate agents who employs or to the branch manager as a contractee. Okay. A real estate agent means any natural person who has a license and the same and employs. So this is the real estate agent employs now. So it is, if you are, because you're doing a course, you cannot be the real estate agent. You can in a certain way. You're doing the course because you need the license. You're employing people, okay? So you are engaging people. So it is the person who is on top. Okay, so property consultants are those who usually go running. This is more in the office. Okay. Um, and branch manager means any natural person who is a holder of a license and is employed or engaged to supervise any property consultant. So the real estate agent is the one on top, okay, the boss. The branch manager is a supervisor, okay? So the hierarchy is the real estate agent, the branch manager, and property consultant, okay? License activity, the activity of a broker or a real estate agent means the acting as an intermediary and he has the property consultants helping him and the branch manager in the process of negotiating and arranging transactions involving and acquiring of so this is to do contracts of sales to sell. Okay, that's what it's saying. Where a real estate agent or a property broker intends to carry out his activities with some other person, they shall form a partnership. So if you have, it's not you who are property consultants, most of you, but the boss, if they decide to work with another person or a property broker, they need to register a partnership. This is according to to the MFSA law. Okay, so and it has to be registered in the MBR at MBR, the Malta Business Registry. Okay, acting as an intermediary, and they shall seek the authorization as a partnership of the board. Apply for a license. So the board, so the partnership is going to have the license prior to the commencement of activity. There is a fine of 20,000 for operating without a license. License requirement. So what do you need for a license? 18 years or emancipated, under 18 but over 16, who under commercial code have authority by their parents, so the parents have to sign that they can do this work. Holds a certificate in real estate, what you're doing, okay? As its subject matters, and it says what it should have. Legal, financial, technical, and communication issues related to real estate, its marketing, and its sale. So this is why we have all these modules, okay? Other equivalent qualifications, if like health and safety. In fact, some of the qualifications that exist, they do health and safety apart. Assessment possible where equivalence only partial. Okay, you should have an assessment as we are doing, etc. Well, license, so application requirements, what you need to submit when you are going to apply for the license, where license activity will be carried out, so the business address or addresses of your offices, to indicate which of these is the principal place of activity, if these are more than one. So if you go into more than one of your offices, you need to say which is your base, real base. For partnership rather than a sole trader individual, to use a specialized form. So if this is real estate agent with another sole broker and they do a partnership. Other requirements listed. This includes license numbers of any directors, so those who will be on top, okay, so managing the partnership. The board grants the license if it is happy with the requirements. There weren't big issues. The big issue was the course, okay? No licensee shall exercise the activity of property broker or of a real estate under any name unless the name has been first approved by the board. So you cannot say you are acting under behalf agent X or Y unless unless it is approved by the board. Okay, it might be that applications for approval of name, the board will consider similarities or other reasons for which. So this is the board licensing board. Okay, so licensed individuals given an identity document, so you would be provided with an identity document, which is to have photograph and other relevant information, including type, registration number, and validity. Okay, so this has also renewal. There is if you are in violation, there is 20,000 penalty. The license will be valid for 5 years unless cancelled, revoked, or suspended before or surrendered. Renewals unless there are grounds not to, as follows: breach of any provision in the Act, permitting someone to act as their agent to exert. So you delegate the agent when you are not registered as real estate agent or a branch manager, because those are make a difference. You stops being fit and proper person by being have a criminal offense and failure to carry out CPD in the 5 years might vary by type of license. Okay, so CPD is you need to continue to update yourself. Okay, that would be a refusal to renew, to state grounds in decision that notify the licensee. Surrender of license, you might actually want to stop practicing, working as a property consultant. This can be done with a written notice at any time to the board. Licensee may at any time notify the board that they do not intend to keep a partnership, and the board shall endorse the notice. Any fees or any dues, fines which were pending at the time of surrender will still be due. So if you have practically something that you had to pay, they will still be due and you might be sued. Okay. So that's all, folks. Thank you for listening. And hopefully you will do well in your exam.